on AM 560, The Answer.
Now, from the Signature Bank Studios, this is Chicago's Morning Answer with Dan Proft and Amy Jacobson on AM 560, The Answer.
Top of the morning, Dan and Amy will be back tomorrow. We talked a bit about it a bit earlier in the program that unsurprisingly this weekend had a lot of Biden administration flacks doing damage control duty, from his wife to his VP to his spokeshuman to his Homeland Security Secretary to his co-campaign chairman. And, even to the press corps, of course, his comm shop. You've got the spokeshuman, KJP, and you've got the comm shop. People like John King over at CNN. Take a listen.
Yeah. The stutter, God bless him. I mean, the man deserves a lot of credit for fighting through that in a very public way with a camera aimed at him every second of every day. For someone to go through that and put up with it, it takes a lot of courage. And he, whether you're a Democrat, or Republican, Independent, people with hardships have to deal with hardships. He deserves a ton of credit for that. I first covered Joe Biden in Iowa in 1987. I was out there covering Governor Dukakis and went to other events. He has never been a great communicator, but he is good in small settings, and he's a good small talker, and he puts you at ease if you're in a small group with him. He's never been great off the teleprompter. And
you see, what Robert Hurd memorialized in that report is just Joe being Joe. That's just Joe being Joe. He's not a great communicator, but he's good in small groups, and he's overcome a lot, and that's all we really should think about. And then you have, so that's one piece of it, right? Oh, Joe's just, he's not good with the English. He doesn't speak of the English particularly well. But that doesn't mean he's unfit for the job, of course. And in point of fact, in those small group settings, particularly in crisis situations, I mean, there's nobody better. And that's the other half of what you heard. For example, Kamala Harris.
Listen, I have been privileged and proud to serve as Vice President of the United States with Joe Biden as President of the United States. And what I saw of that report last night, I believe is, as a former prosecutor, the comments that were made by that prosecutor, gratuitous, inaccurate, and inappropriate.
How dare you, sir? And they're also inaccurate because, I mean, the most difficult part of Ali Mayorkas' job at Homeland Security is not, he's not even trying to slow the flow of migrants coming across the border, is not trying to come up with cover stories for the administration's policies with respect to the border. It's just preparing for the meetings.
The most difficult part about a meeting with President Biden is preparing for it, because he is sharp, intensely probing, and detail-oriented and focused.
Yeah, it's got to be intimidating to go into a meeting with that kind of intellectual firepower across the table. And he's going to be exacting in his demands. So there it was. He is a intellectual force to be reckoned with. He doesn't speak of the English so good. How dare you bring up his dead son and say that he forgot the date. How dare you, sir? Gratuitous, inappropriate. Her is a Republican operative appointed by Trump to the Justice Department, so this is a political hit job. Did I leave anything else out in terms of this cover story? Oh yeah, one thing. 80% of the American people don't believe the people you just heard. They don't believe them. For more on this and what might be possible if it were to come to that, meaning a replacement for Biden, which I've always said, barring a health event, and I don't mean what occurred on Thursday night, he is going to be the nominee. He's going to be on the ballot. I've said that from the beginning. All of the Michelle Obama this and Gavin Newsom that conspiracy theories, and I still think that, but there is a renewed conversation about, and I've saw people, articles of impeachment, 25th Amendment. So let's talk about it with our friend and legal expert, Andrew McCarthy, former Chief Assistant U.S. Attorney, Southern District of New York, contributing editor, National Review, author of the bestseller Ball of Collusion, The Plot to Reagan Election and Destroy a Presidency. Andy, thanks for joining us. Appreciate it.
Dan, great to be with you.
So, I mean, the short of it is, if Biden doesn't want to leave, there's no real accessible way to force him out, is there? And even if there was an inclination to do so, and based on the response you're getting from within the circles of his party, at least publicly, there isn't much of one.
No, there's not. I mean, the 25th Amendment could be invoked, but first of all, that's a political calculation, not a legal one. There's not like a legal standard that says, if you're X amount unfit, this automatically triggers. It's got to be triggered politically, which means by the vice president and the cabinet, or at least half the cabinet. It's really rigged is the wrong word, but the amendment is geared so that unless you have a president who is, what they had in mind, Dan, when they enacted that or ratified it, was the JFK situation. If he had lived through if he had been
right.
Conscious after, not conscious, but if he had been, his organs
technically
had been
alive,
continuing to work, but or Woodrow Wilson, that whole situation. So if you have a president who's not completely out of it like that, I don't mean just like hyperbolically, rhetorically out of it, like we refer to Biden at times, but like really out of it, then yes, you could invoke it. But otherwise, a president who doesn't want to be removed won't be removed under the terms of the amendment. I don't see any stomach at the moment for removing him, but I just would point out it was a shocking poll. I think it was an ABC poll over the weekend that 86% of the country doesn't think this guy is up to the job.
Yeah.
And I mean, how many issues in American politics do we have that are 86% issues?
No, right, and right, and what you're supposed to, the spin that they came up with. I mean, I'm not saying they have a strong hand to begin with, but this, what he does remember is he created all these jobs and he did all this. He's, it's like, yeah, okay, Mitchell Andrew, all right, that's not quite going to be enough. That what he remembers is all the wonderful things he's did. First of all, many of that 86%, a majority, in fact, don't think he's done such a wonderful job. On top of that, it's like, it's the typical "don't believe your lying eyes" sort of defense, and it's hard to persuade people not to believe their lying eyes.
No, that's right, and also it's clear he doesn't want to go. And look, if it was. We're all thinking about what would be great for the country, or what would be the best for the country. And, you don't really have an alternative here that would be great for the country. It's not like, he leaves and you get Harris. That's,
Right.
But if you put it in his, you try to get into his shoes, when you have a guy who's been on the national stage for half a century and, I think despite his very severe flaws and limitations, somehow has managed to have like the two highest jobs that you can have in the executive branch. Mm-hmm. He's at the pinnacle of power. To expect him to get out because you think he should get out when he wants to stay it's just not realistic. And, look, he's got a very good chance of beating Trump. I still think he's the favorite if it's him and Trump. And I know things are bad now, but I think sometimes people don't realize how bad this is going to get for Trump in the end. I mean, they have like $250 million that they're already buying up ads because Trump has to divert so much money to legal help, and the Republican Party is run completely incompetently, so they don't have money. So the Democrats the deluge that's coming starting around like late August, September it's going to be like nothing we ever saw before.
Well, I mean, that's true. And the real wild card for me as it pertains to Trump is how people react if any of those cases that are pending get to trial and an adjudication. And so, in other words, if he's convicted of any crime before November, and then you get the convicted felon messaging on that topic. And speaking of which, let's divert to Trump for a second. I mean, is it your handle that the only case that looks more likely than not to get to trial before November is the Alvin Bragg case in Manhattan?
I still think that they badly want to try the Washington federal case.
Oh, sure.
As a practical matter, I don't see how Judge Chutkan can schedule that trial until we see what the Supreme Court does with the obstruction case involving the J6 defendants. And we're probably not going to get that until late June, just so your listeners understand why I'm saying that. Even though President Trump is not a party in that J6 case where the Supreme Court is apparently disturbed by the way prosecutors have stretched that statute, the same statute that's at issue in that case is the main two counts of the case against President Trump in the 4-count indictment. So I don't see how Chutkan can start. If the Supreme Court is going to give guidance on that statute, I don't see how she can start the case prior to that. So I don't think that case can go before sometime in July. And depending on what the court does with the obstruction statute, it could completely change the case. So we'll have to look at that. But that's the case they really want to go to trial on. I suggested over the weekend, they'll never do this because it's a good idea, but I think if you really wanted to get the Florida case to trial, what Biden should do is pardon Trump on all the classified documents counts, which there's 32 in that indictment, and sweat it down to a straight obstruction case. The reason that case is bogged down is because the Classified Information Procedures Act requires that all of the admissibility issues get litigated prior to trial, and there are appeals. So if you got rid of the classified information counts and just made it a straight obstruction case, which is what I think they should have done in the first place, you could actually get that to trial, and it would be the right thing to do because, looking at what Hurd did with Biden, the idea that the difference between the Biden case and the Trump case is that Biden cooperated and Trump obstructed, so they say. That's a reason to charge Trump with obstruction. It's not a reason to not charge Biden with classified documents. If I commit a murder, but I'm very cooperative with the investigators, they're not going to say, well, that whole murder thing, let's forget about that.
Right.
I'm going to be charged. So it's not a good reason not to charge Biden, especially when you charged Trump. So just basic fairness, they ought to cancel out the classified information counts on Trump. And if they really want to get the case to trial, the only way that case is getting to trial is if they get the classified stuff out.
Well, so on her, I mean, that is actually an interesting idea, probably a good one from their perspective. The Robert Hur, you heard part of it there. J.B. Pritzker saying too, I smell a political rat. Robert Hur did this, and he included the language there about Biden's senility because he is. It's a hit job from a MAGA cultist that was in Trump's DOJ. Or it's Robert Hur covering his ass because he has to have a rationale for why he's not charging Biden, and this is it. This is what he came up with. But I mean, give us your assessment of Hur's decision and the quality of the report that he issued.
Well, I think his reasoning is flawed, but not in a way that in the opposite way of what Pritzker and the rest of them are suggesting. I mean, I think it's ridiculous, first of all, to accuse him of a political hit job, because first of all, the bottom line here is had a case where the guy willfully committed the crimes, but he's given him a pass.
Right.
So, I mean, right away you're starting with the main conclusion is he doesn't think he should be charged. But the other thing that people need to understand about the way the regs work, they explicitly say this is supposed to be a confidential report from the special counsel to the attorney general, where the special counsel lays out all of his reasoning. So in theory, now it's become a convention that these things eventually get publicized, and I'm sure Hur must have written it with an idea that the public might see it. But it was up to Attorney General Garland what got released publicly. Hur's job was to give Garland a full report on why he thought Biden shouldn't be charged. And he would have had to do, if he had charged Biden, he would have had to do the same thing, explain his rationale. And if you're a prosecutor and you're explaining to your boss why I think, even though we have overwhelming evidence, and the reason I say it's overwhelming is this is where I think the report is flawed. He found that Biden willfully violated the law, and the statute only requires a showing of gross negligence. So willfully is the highest intent standard in the criminal law. Gross negligence, you don't even have to show that the guy intended to violate it, just that he was grossly negligent in carrying out his obligations to safeguard national security information. So to me, that's an overwhelming case to charge. And the other flaw in his rationale, I think, is that if you say that Biden shouldn't be charged because the jury would be very sympathetic to him as a well-meaning elderly guy with a bad memory, the issue is not what his state of mind is now.
Right.
The issue is what his state of mind was at the time that these acts got committed. Some of them go back to when he was in the Senate, which he left 16 years ago, and some of them go back to when he was vice president, from 2008 till 2016. So that's 8 years ago. He was a very different guy then than he is now. But the other thing is, if you're the prosecutor reporting to your boss about why we don't charge this, if one of the reasons you don't charge it is, if I charge this guy, I'm going to be in a 6 to 12 month litigation over whether he's fit to stand trial, you have to disclose that to the boss. You don't have a choice about that. And that's a significant issue here. Even if Biden thinks he's fine, any competent defense lawyer, if he were to have gotten a multiple count felony indictment, would be throwing everything at the court that you could throw at the court to try to get him out of it. And one of them would be he's not fit to stand trial. So that was going to be a significant issue. The thought that you wouldn't put that in a report is crazy. And the fact is, if Garland thought that it shouldn't be out there, he could have redacted it. But it was Garland's choice to make this report public, and it was Garland's choice to not put those, to not redact those things before they went out. And I think this is just another one of these things, Dan, where it's like sanctuary cities, They all want to be sanctuary. Chicago wants to be a sanctuary city until you actually have to be one, right?
Yeah, right.
And then you have Biden and Garland. They want to tell you how transparent they are. Well, this is transparency. Transparency isn't something you just get a medal for. It's when you put out information that is very unflattering. That's what it requires. So they run around telling everyone they're going to be transparent. This is what it is. He put it out.
On the Supreme Court oral arguments in the Colorado ballot access case last week, it seemed to me that maybe Justice Roberts sort of had the definitive exchange with the Colorado attorney, the attorney for the state of Colorado, where he basically made the argument, a very practical one, that said, if we allow this, then how do we stop this from being a wildfire across the country, and the Supreme Court ultimately being put in the position of deciding, which handful of states where both men are on the ballot count in terms of deciding who the president, who a president would be. Just a practical matter of the precedent that Colorado would set if that state Supreme Court decision was allowed to stand. Seems to me where the court is, I know it's dangerous reading into all arguments, but boy, that was coming across pretty strongly, even across sort of the ideological divide there.
Yeah, I think that's right, and I think he's obviously going to write the opinion. When the Chief Justice is in the majority, he gets to write it or assign it. I'm sure he'll write it himself. I think what he wants is a 9-0 opinion if he can do that, and I think it's very possible in this case that he could. What I'm worried about, though, Dan, is that I think he can get consensus on that point about how if you let a state do this, you can have complete chaos. I think the court's on board with that. But the problem is they don't want to get into what an insurrection is and what you have to do to commit one and all that jazz. So they're looking for consensus that keeps them away from that because that's politically charged. But the thing is, if they don't solve that, what you're going to have happen is if Trump wins the election, the Democrats in Congress, who are not the states now, right? The 14th Amendment says it could be invoked by Congress, and Section 5 of the 14th Amendment says Congress is the one who's in charge with enacting standards to enforce it. So what the consensus the court is forming is around what states can do. It's not about what Congress can do. And I could easily see if Trump wins the election, Democrats in Congress at the next January 6th say that they don't want to have him seated because he's not eligible, because he's an insurrectionist. And then we're right back to the drawing board. So I really hope they decide what an insurrection is, but I don't think they're gonna.
Well, couldn't they also just decide to say, well, look, we're not going to decide, we're not going to define what an insurrection is because the individual hasn't been charged with anything that resembles seditious conspiracy, anything that resembles, it's something that's tantamount under criminal law to an insurrection. So if you're not charging him under criminal law or in a successful impeachment proceeding with it, then it's not an insurrection.
Yeah, I think that's right, and I hope that they go there. What they could say is, after the 14th Amendment was ratified, Congress enacted two pieces of legislation that were relevant. One was a civil lawsuit to enforce Section 3 of the 14th Amendment. The other was what comes down to us now as the insurrection criminal statute. The civil lawsuit is no longer on the books. It was enacted in 1870, and for some reason it was repealed in 1942, but we still have the criminal statute. So what I hope they say is, we're not going to get involved in what an insurrection is, but Congress has gotten involved by enacting a criminal statute, and at a minimum, somebody needs to be convicted of it before you can say he's an insurrectionist. So, the Justice Department, as you point out, has never charged Trump. They've never charged anyone. They've charged, I think, was it 1,260 people now, I think, have been arrested in connection one way or another with the Capitol riot. No one has been charged with insurrection.
Andy McCarthy, former Chief Assistant U.S. Attorney, Southern District of New York, contributing editor at National Review, author of the bestseller Ball of Collusion, The Plot to Reagan Election and Destroy a Presidency. Andy, thank you as always. Appreciate it.
Thanks, Dan.
And Andy joined us on the Turnkey.Pro answer line.